Afan Valley Ltd and others, and Lupton Fawcett.
Yes, Mr. Pickering, good morning.
Good morning, my lords. My lords, perhaps I can start with the introductions.
Yes.
I, together with Mr. O'Doherty, appear for the claimant appellants. My learned friends, Mr. Saul, King's Counsel, and Miss Manby, appear for the defendant respondent.
Yes.
And as your lordships will be aware, the two matters before the court, the primary matter is the hearing of the claimant's appeal.
Yes.
Permission having been granted by Lord Justice Dingemans in January. And in addition, also before the court is the claimant's application to produce further evidence and to rely on a further draft and particulars of claim. My lords, as for papers, we understand that an apology is in order. The court should have a total of 4 bundles.
What do you think we should have? Because we've been given a plethora of things.
My lord, 4 bundles. First of all, the core bundle.
Yes.
Secondly, the supplemental bundle.
Which comes out as 3 volumes. Yes.
My lord, yes. And that bundle contains material relevant to the appeal, but also the application.
Yes.
And 2 authorities bundles. My lord, one of those relates to the appeal itself, some 377.
Yes.
And my lord, the second authorities bundle relates to the application. It's some 186 pages. And we understand it's that bundle which has caused the difficulties for which we all apologise.
Well, I don't know where the difficulty has been caused, but the bundles of authorities, as you know, should be sidelined, and certainly initially the application authorities bundle was not. And there was a direction from Master Meacher quite a long time ago that agreed bundles of authorities should be lodged in July, and certainly it didn't reach us until very recently. But not to worry, these things may seem very trivial compared to the things we are going to argue about, but things like sidelining, although it's a very minor point, is actually of quite significant practicality, practically speaking, because if you expect the court to pre-read any authorities, it obviously makes it a great deal easier if we know what we're looking for, rather than having to read a case from beginning to end. Anyway, there we are.
Well, we do apologise for that, and the oversight was certainly ours, it appears, and we apologise for the lateness of the sidelining and the filing of that additional bundle.
Yes, I've also got something called an unagreed supplementary bundle, but we don't need that anymore. Is that right?
My lord, correct.
Yeah, get rid of that. Thank you. Yes, now we've seen your very helpful timetable. Thank you. And as you would have seen, we're content to have the amendment application argued first.
My lord, yes. In relation to that, I'm going to hand over to Mr. O'Doherty.
Yes. Okay. Yes, Mr. O'Doherty.
Good morning to you. We start then in the supplemental bundle, the application notice being at page 443.
Yes.
So, my lord, with the application notice before the court, may I take the court to the genesis of the application?
Yes.
The genesis being in the core bundle within the original order of Mr. Justice Sheldon, which is the subject of the appeal. The judgment is behind tab 6 in the core bundle.
We don't have any tabs.
Yes, it's another minor but irritating flaw.
If you can give us the page references.
I will do so, my lord. The start of the judgment, so your lordships know the document, is at 68. May I take the court to page 80, paragraph 65.
Yep.
This is the point at which the issue, which is the subject of the application, was initially raised at the court. Mr. Justice Sheldon took argument from Mr. Pickering with respect to whether or not compensation was sought pursuant to section 26(2)(b of FISMA. And it is the 4 lines at the end of this paragraph that I would take the court to, the laws.
Yes.
However, says Mr. Justice Sheldon, I was shown no evidence that any investors had sought any compensation. This was not a matter which was pleaded, despite the 5 attempts by the claimants to plead their case. It was not an argument, therefore, that I was prepared to take into account when considering the application before me. My lords, we say he is wrong when he says it was not before the court. And we say he is wrong because of the evidence contained within Mr. Armstrong's first witness statement. Mr. Armstrong's first witness statement being the evidence that is sought to be relied upon in the application. May I take your lordships to the evidence so that it frames the way in which the application is put? For that, I return to the supplemental bundle, my lords, page 451.
Yes. Sorry, maybe I'm missing something. This is the evidence you now want to get in.
Yes,
It's dated March of this year.
yes.
So Mr. Justice Sheldon was not wrong to say that he was shown no evidence because he wasn't shown this because it didn't exist.
That he was shown no evidence, but his assertion was that this matter wasn't pleaded.
Well, that's a different point.
That's the point that I say he was wrong on, the law. So
Well, if it's already pleaded, you don't need an amendment. But you want to amend to plead it because he says it wasn't pleaded.
yes,
Yes,
and
right.
I say he is wrong about it not being pleaded. The evidence that Mr. Armstrong gives demonstrates he is wrong. And the second part of the application is that we seek the amendments in 8.6.
Yes.
May I take you to paragraph 15 of Mr. Armstrong's evidence in order to make good the submission with respect to Mr. Justice Sheldon being wrong?
It's back to paragraphs 177 and also 241 of the claim already pleaded.
Indeed, my lord.
So that's what the point turns on.
And we say this evidence is therefore essential because it demonstrates in this appeal that Mr. Justice Sheldon was wrong to say that the compensation claim was not already pleaded. It was pleaded by way of.
But you don't need, I'm sorry, I'm being very stupid, but you don't need evidence from a solicitor to determine whether something has been pleaded or not. What you have to do is look at the pleading and see if it's there.
And the Lord, yes. And Mr.
Well,
Justice.
so why do you need evidence for that?
Well, Mr. Justice Sheldon erroneously did not see that the indemnity point pleaded the point that he says wasn't pleaded.
Well, you may or may not be right about that, but I don't see that it gives you, I don't see why you need evidence for it. The evidence you need to know if something is pleaded is the pleading. Yeah, anyway, there we are. You say that it is already pleaded.
The compensation point is already pleaded by reference to what Mr. Armstrong says in his witness statement. May I correct a misapprehension? This evidence is Mr. Armstrong, the liquidator of the claimants. It's not a solicitor.
Yeah.
And what he says is, we have compensation claims that will arise in the liquidation, and when they arise in the liquidation, because they are not claims that he has properly brought in the liquidation, at the point at which those claims are brought in the liquidations by way of proofs of debt from the investors, then the companies will seek an indemnity for those losses. And that's the essence of what he says at paragraph 15. So we say, by reference to the evidence that now explains the error that Mr. Justice Sheldon made, we do already have a claim for compensation pleaded, as your Lordship has pointed out at paragraphs 177 and 241.
Yes.
So I say that frames the first part of the application being both for the amendments and for the reasons behind why the claim is pleaded the way it is, because that frames the amendments, which are an explanation of the existing pleading, to expressly plead in clearer terms that the Section 26 claim includes a claim for compensation. And I say the court should treat on a standalone basis the late evidence that Mr. Armstrong puts in, or that rather the claimants put in with Mr. Armstrong giving the evidence. That should stand separately from the court's consideration of the amendments. The amendments largely being to plead with greater particularity the Section 26 claim and plead it expressly as compensation. And that clearly needs to be done, my Lord, because Mr. Justice Sheldon missed the point. That being essentially the start of the ladder Marshall type analysis. The court will be aware of the numerous sets of amendments that are pleaded in this case.
Yep.
And the considerable criticism on the other side of the court with respect to those amendments, and they are at a headline level 7 sets of amendments. And I say, in order for the court to properly consider the application, a short trot through the amendments to demonstrate that whilst the case has been amended 7 times, they are not 7 sets of substantial amendments. There are substantial amendments, there are corrections to those amendments, and there are several steps that were really relatively minor. Whilst the claimants do not shy away from the fact the claim has been amended 7 times, it is not right to say that those are substantive amendments in each case.
Well, when you say it's been amended 7 times, I've not myself been through all the various iterations, but what is the formal position? Has the claim been formally amended? No. So you have the original particulars of claim, and you've had a number of attempts to put forward draft amendments.
Yes.
Yes.
And the draft amendments were the subject of the strikeout application, which was successful with respect to striking the claim against this defendant out.
Yes.
But Mr. Justice Sheldon, if he was found to be wrong, for example, by this court, he has allowed a series of the amendments.
There were 1 or 2 he disallowed, I think.
He did not allow all the amendments in, my Lord. He allowed the bulk of the amendments in against this defendant respondent. I can take your lordship to the paragraph if that assists.
So is this an overly simplistic way of putting it? He assessed the strikeout on the assumption that the amendments would be in, or is that not quite right?
Not quite right.
No.
He assessed the case against each of the issues that were the subject of the amendments,
Yes.
allowed some of them in. A series of the amendments were agreed for the purposes of the strikeout application, and he disallowed a series of the amendments.
I see. Yeah.
And his judgment on these points is actually relatively short.
Yeah.
The last 2 sets of the amended particulars of claim, which are referred to as APOC 6 and APOC 7, are within the supplemental bundle. One is multicoloured in order to demonstrate the certain points at which certain of the amendments are made. One is a single set, a single coloured set of pleadings, which the appellants would seek to rely on if successful in this appeal. On the basis that the respondents sought to introduce the coloured version as well, I proposed, by way of introduction, to take your lordships through the multicoloured version.
Okay.
That is found at page 583 of the supplemental.
So this has red and green. Does it have any other colours?
No, it has red and green. It has red and green underline and red and green strike through.
Right.
And I propose to take the court through a whistle-stop tour how these amendments were.
And this is what number do you call this?
This is APOC 6.
APOC 6. Okay. And can you tell me what the red and green are?
Yes. So the red amendments are everything that took place up until the 1st of March 2024. The green amendment.
So are these the ones allowed by Mr. Justice Sheldon, or
Unfortunately, it isn't that simple. A series of the amendments were allowed. Some were red, some were green.
Are these the ones before him?
Yes. So the red was before him. Some of the green was before him, but not all of the green.
Oh.
Yes.
Okay, so what is the green?
The green were amendments that were made following the adjournment of the November 2023 application, because there was, your Lordship may or may not have ascertained that there were 2 attempts at this strikeout application. One in November 2023. There was late disclosure before that.
This isn't. That's not right. The green in here, amendments that the claimant seeks to reduce on appeal. There are some.
That's what I had assumed, but
there are some deletions to reflect what was not allowed in at all by Mr. Justice Sheldon. Were he wrong about strikeout? But the green, for the most part, is the amendment sought to be introduced on appeal, and the reason we've asked for this document to be included and to be the one that the court should look at. I apologise for the interruption. I just didn't want the court to proceed on the basis of a misunderstanding, is because it's useful to understand what's new now.
well, that is what I would find helpful for the application to amend which you are putting before us, is to be able to compare what was before Mr. Justice Sheldon and what you now seek to put before us. And I thought that this document did that, but it sounds as if you're not clear that that is what this document does.
Your Lordship is correct.
The green is all subsequent to his order.
Yes.
Right.
Cut through this. So there is an application notice which refers to draft amended particulars of claim. Is that the document you've taken us to?
Yes.
Good.
Yes, okay. So if we see anything in green in this document, we can assume that it wasn't before Mr. Justice Sheldon. Is that right? Thank you.
Could I take your Lordships to the chronology in the court? Demonstrate when the amendments were made.
Page.
Page 62 of the law.
Yes.
My Lord, page 63, where the first amendments are introduced, between the whole bunch.
Well, when was the claim issued?
The claim was issued April 2022.
Claim form issued. Thank you. And where are the original particulars of claim?
The original particulars of claim are in the court bundles.
Yep.
They are on tab 7.
We don't have tabs.
My Lord, yes. Page 135.
135, thank you. So this is what was originally served with the claim form.
Yes.
No, 135 is not right, that's in the middle of a pleading.
102.
102, thank you. And when was that served? Looks like 10th of
10th
August.
of August, or 2 lines down from the
Yep.
application.
In the index on the right-hand side of my screen, this is called an amended claim form, and there is no amendment to the particulars of claim. The amendment is only to the claim form, which is at page
Okay, so we've now got to August and we've got the original particulars of claim. Yes?
Yes.
Thank you.
The first date I would then take the lordship to is the 30th of June 2023, about 8 items down from the claim file issue in chronology.
So that's APOC 1.
APOC 1.
Yes, we don't have that. Or do we?
No, no. It was considered that.
I'm not criticising, I'm just asking.
Yes.
Yes. Yes.
So
And so that's June.
that's June 2023.
Yep.
Now, the law, I can take you through the substantive amendments in brief form there, or I can take you through the dates of each of the sets of amendments, whichever court might consider most helpful.
Well, I think if we need to get into this at all, I mean, I'll tell you that I think that what we actually need to decide is whether you should be able to amend from what was before Mr. Justice Sheldon to what you now want.
Yes.
That's the ultimate question.
Yes.
If you think it's helpful for us to know how each set came in, then I think, speaking for myself, would be more helpful as you go through the chronology to say what happened in June, what happened in August, what happened in November, and so on.
Then I will do that, my lord, as it does frame the application.
Right. So what happened in June?
In June, there was a fairly wide-ranging set of pleadings from paragraphs 58 to 171. In APOC 6, which I could give you the page references for, that's 607 to 674.
Yes, but we can't just look at this and say anything in red came in June. No. So I'll be perfectly honest, to be told there was a wide-ranging set of amendments doesn't help us very much.
I was going to elucidate.
Thank you. Yes.
Expanding out the duty to advise and
Yes.
the retainer, which was at paragraphs 85A
Yeah.
and paragraphs 90 capital A to 90 capital E.
Yeah.
Sorry, can you just give it again? Page.
85A,
Yeah.
paragraphs 90A
Yes.
to 90E.
Yep.
Thank you.
Those were amendments expanding out the duty to advise.
Yep.
And developing out the retainer. There were then consequential amendments to the breach section and the loss section, which are found at 163A and 163B, with then a series of amendments to each of 21 pleaded breaches at paragraphs 1631 to 16321. The breach section is extensive, the page numbers for that being 652 to 665.
Yep.
Those were the bulk of the amendments, my lord. There were various sundry amendments to update companies moving from administration into liquidation, updates to investigations by the Serious Fraud Office. So that is are not of critical relevance, but your lordships will see some sundry read throughout those paragraph numbers. Now, the second set of amendments.
What did it do about loss? Because you said there were changes to loss,
Yes.
but where do we find that?
Loss is found at 166 capital A, which is at page 669, through to 171 at 674.
can you, I'm sorry, I'm being a bit slow. Can you tell me what the loss claimed in APOC 1 was?
I understand, I don't have the document open, I understand it's approximately 63 million.
Yes, but how was it characterised? What did the loss consist of?
The loss consisted of the sums invested by investors into the 20 plus schemes.
Right. Thank you.
My Lords, I propose to move to the second set of amendments.
APOC 2.
APOC 2 being in August 2023.
Yep.
This was a far more limited set of amendments. The removal of the 9th defendant, unrelated to this defendant, respondent.
Yes.
And at paragraph 168 on page 673, an amendment redrafting the appropriate dates for limitation purposes.
Yes.
I propose to say no more about the second. The next month, my lord.
Mr. Doxey, I've just heard the clock strike 11. I was looking at the timetable. Your submission is meant to be finished by 10 to 11. This strikes me as it's going to take rather longer than anticipated.
My lord, perhaps not.
Okay.
Because with respect to the substance of the application, my submissions are very well contained within the application notice itself. So I have a limited expansion. So if your lordship is finding it helpful with respect to the landscape of the amendments, then I will deal with that. If your lordships would rather I turn to the substance of the application notice, I can finish my submissions within 5 minutes.
Well, if you think, I'm not going to tell you how to argue your application. If you think it's helpful for us to understand the various iterations of your amendments, then you ought to carry on going through them. But I am conscious of time.
Yes.
The longer you take on this, the less time there will be for your leader to deal with the substance. Put it that way.
The third set of amendments dealt with, in September 2023, dealt with a reduction in the underlying claim because of limitation.
Yes.
So an acknowledgement that there were limitation issues, updated schedules were provided. Those are at 507, 508 and 582.
Yeah.
So the third set of amendments of limited impact from the defendant's perspective because they were reducing the claim.
That's September 23.
September 23.
Yep.
The fourth set of amendments were relatively extensive. These go for the reasons the November 2023 application was adjourned until February 2024. There was disclosure just before the first listed hearing. That disclosure included evidence with respect to advice received from Counsel Mr. Green. Counsel Mr. Green had, claimants say, provided extensive advice with respect to the underlying claims.
Yep, but this all goes to breach.
All goes to breach.
Yes.
Those amendments were largely allowed in, subject, of course, to the fact that the claim was struck. The fifth set of amendments, APOC 5, were limited to changes in quantum. Paragraphs 173, 178, 251. Those are at pages 675 to 678 and 724. 724, my lord.
Thank you.
We're now in January 24.
January 24.
Yep.
Then the sixth set of amendments were in March 2025.
So that comes after the judgment.
That comes after the
So APOC 5 is what was before,
the law, yes.
right. At the risk of confusing myself, is that what is in red on APOC 6? Not quite, I think you said.
Yes.
Yes?
Everything in red in APOC 6 was before Mr. Justice Sheldon. Anything in green was not.
Right. Thank you.
So then, if I may, my lord, I shall return to the application notice.
Yes.
When we say the application is actually relatively simple. On the basis of the argument that was before Mr. Justice Sheldon, we say that there was a pleaded claim for compensation, but he did not accept that, and therefore, when the point was argued at the permission to appeal hearing, when the point was argued rather by Mr. Pickering,
When was the PTA hearing? This is the one before Lord
Lord
Justice Dingemans. Yes,
January 29th.
that was in May.
May.
No, it was in
29th of January.
It's in
29th
January.
of January.
Oh, I'm sorry. Yes, I see. Yes.
And the point that was argued then was, it did not appear clear that there was a claim for compensation.
Yep.
Therefore, amendments were made in APOC 6 to plead the point out. We say more clearly, the defendant appellants say, well, you haven't pleaded compensation at all. We say, actually, we have, by reference to the original pleadings, which deal with the operation of Section 26 of FISMA, whilst not dealing with the word compensation in terms. The operation of Section 26 of FISMA does deal with compensation. Married to that, there is Section paragraph 177 of the existing pleadings that refers to the indemnity I took you to by reference to Mr. Armstrong's witness statement evidence. We say this point is already pleaded, and that to the extent the amendments are, as the respondents say, late, they can be dealt with because they are expanding upon a point that we say was already before.
When you refer to compensation, you're using it in the technical sense set on section 26(2)(b),
Yes.
as opposed to 26(2)(a),
Yes.
return of the investment.
Yes, and that's the contentious point, my lord. That's the point that the respondents say that you didn't give us adequate notice. We say, well, the operation of section 26(2) is clear from the face of it. But in any event, the way that the liquidation operates, and this isn't pleaded, but this is, we say, a matter of fact that needs to be before the court, hence Mr. Armstrong's evidence, is that claims of this nature are brought at the appropriate time in the liquidations, and if they are not brought before an order in this case is made, then they will need to be brought by way of indemnity. We say that's why Mr. Armstrong's evidence is essential. The essence of the underlying application for these amendments is that they assist the court. The respondents say they are too late. We say, no, they are not. If the appeal is successful, we are at a very early procedural stage. There is not even a defence. So we say this can be dealt with. There is no prejudice. The lateness of amendments by reference to the authorities that the respondents will take you to by reference to amendments after a trial.
Well, I understand that there are authorities on lateness by reference to trials, but one of the authorities in the bundle, the decision of this court, judgment given by Lady Justice Arden in Elwyn, and one of the things she said, paragraph 49, is that Ladden Marshall applies to the reception of fresh evidence on applications under 3.4, which is what this is, I think, and the same should apply to amendments to statements of case adduced for the first time in the Court of Appeal to avert the unfavourable outcome of an application to dismiss under 3.4. That's our case, is it not?
Well, my lord, yes, but we also say not particularly no, because of the underlying existence of the pleadings, that this was a point that was already before the court.
Well, I'm sorry, I think I'm repeating myself. If it's already before the court, you don't need the amendment. If it's not already before the court, you do need the amendment. But then you run straight into what Lady Justice Arden says.
And if that's the case, and if that's the way that the analysis runs, then I fall back on the court having to consider the position against the overriding objective.
Well, are we or are we not bound by what she says in that case?
Insofar as her judgment goes, yes, but it does not preclude the court from considering these amendments against the overriding objective. So I say the court is able to, if the court considers these amendments, the court is able nonetheless to allow the amendments in, and I say it should allow them in against the evidential background that there are pleadings that deal with the point and that the amendments are expansive amendments to assist the defendant to know its case. They do not cause it any prejudice.
Now, you've addressed this as if the substance of the amendments is to plead out a claim in respect of compensation under 26(2)(b). But I thought, maybe I misread it, that the amendments do rather more than that. They plead matters called immediately something liabilities and so on and so forth.
And to the extent they do it, again, they fall within the same category of amendments that assist rather than introduce new points. So they expand what and build upon existing points that are made. For example, sales commissions pleaded at 12.5% are then expanded upon as immediately incurred liabilities.
Well, why is that not a new point? Looks like a new point. Doesn't seem to be there in the previous version.
To the extent the Lordship is not satisfied that it is a point that simply builds on an existing reference to sales commissions, then I say...
Well, where's the... Sorry, I missed that. Where's the existing reference to sales commissions?
Does your Lordship have page 599?
599, yes.
In the supplemental bundle.
Supplemental bundle below.
Thank you.
The paragraph to which I refer is 42, a series of subparagraphs. 42 starts on page 598. The amendments, to the extent that they should be considered by the court as new, are the green on page 599.
Yes, I see. Okay, thank you.
So, my lord, the reason that these amendments have been pleaded out and expanded upon at this stage was at the permission to appeal hearing, Lord Justice Edmonds suggested that that was appropriate to do.
Yes, but he made it clear he wasn't saying anything about.
He wasn't giving permission.
No.
But the view is taken that if it had already been clear within the court that amendments were required, the claimants felt it appropriate to make the application.
Yeah.
In order that the case was expanded upon, so that the defendant respondent had less of an argument that they didn't understand the case. So it is against that context. And in that context, I lean back against the overriding objective sitting behind the latter martial principle.
Well, the overriding objective points both ways. On the one hand, if you've got a viable claim, you ought to be allowed to have it tried. On the other hand, that people ought to be entitled to come along and argue a case, and once, if they win, not to have to face a different case once they've won. So I'm not sure the overriding objective takes you very far, because what is just depends on all the facts, and as I say, the points both ways.
My lord, I think you have my submission. So
Yes. Okay. Thank
so,
you.
Lord, I'm very grateful.
Thank you very much. Yes. So, Mr. Seoul, is it?
I go for Saul, but I
Saul.
don't take any pronunciation personally, my lord. Yes, my lord, that was excellent.
It's very annoying to have your name mispronounced by the bench.
Well,
So
Excuse-
if it's Seoul,
Saul is good.
yes, Mr. Seoul.
There are options, but that's wonderful. Thank you, my lord. My lord. Approximately a year after the first instance hearing, they have applied to introduce the 7th version of the particulars of claim, 7th version.
You call it the 7th version, but we've been calling it APOC 6. This
APOC
is
6, because you start with particulars.
start with the
of claim
original,
and then
yes.
6 amendments.
yes.
We had 5 amendments by the time of the hearing before Mr. Justice Sheldon. I entirely agree, not every single version of those amendments was drafting large swathes of new text into the document. Some were,
And some were beneficial to you,
less
sort of
significant. Well,
dropping
well,
statute barred claims.
put it this way, my lord, it wasn't a voluntary act, it came under sustained pressure in
Yes,
the strikeout application, which identified the statute bar claims which had not been abandoned prior to the strikeout being issued.
Yes.
Now, and they now seek to introduce not only that, but additional evidence not before the first instance judge. And my lord, it wasn't just multiple versions of pleadings that we'd had by the time of the hearing before Mr. Justice Sheldon. We had multiple rounds of evidence. The claimants themselves had served 2 rounds of witness statements, totaling 45 pages, with over 950 pages of exhibits at first instance. Now, what I'm going to show you is that they had every opportunity to bring forward the case they wanted to bring. We intimated the strikeout arguments in a letter sent in February 2023, almost a year before the hearing before Mr. Justice Sheldon.
Yep.
I'm going to deal with the application to amend first and then the application to introduce new evidence. I'll do so quickly, but hopefully clearly. They are subject to slightly different tests. I recognise, my lords, in the overall scheme of things, the tests might really be quite similar. But strictly speaking, where applications to amend are concerned, we're in the world of qua the judgment of Mrs. Justice Carr, as she was then reinforced by the decision of the Chancellor in Acasta, and we then have the decision of Lady Justice Arden in Aylwin. Whereas the application to introduce evidence, strictly speaking, is Ladd and Marshall coupled with the overriding objective. In this case, I'm not sure it makes a great deal of difference because none of the requirements are satisfied for essentially the same reasons. Can I make one point before I develop my submissions on the application to amend, which is this. It's been suggested to you that the purpose of these amendments is to introduce a claim for compensation using the technical expression of that term, as my Lord Justice Holgate pointed out, compensation within the meaning of section 26(2)b of FISMA, as I will call it, I hope, acceptably. That is not the case. That is not a fair characterisation of these amendments. I'm going to demonstrate that point by showing you one passage of the green that they seek to introduce on appeal to this court. And it is Supplemental Bundle, Volume 2. I don't know if my lords have tabs in their supplemental bundle.
No tabs.
May I ask whether it would be helpful at some point, even if it's after the hearing, for tabs to be added? It just separates the documents out. I'm in your hands, but it certainly helped me, and I've had this before actually, in the Court of Appeal. It's not good enough that you don't have tabs, it's all of our faults. If it's helpful to introduce them, it would
Speaking for myself, it would be helpful if someone could deliver to my clerk a set of tabs, which can then be inserted into the supplementary bundle and core bundles. And indeed, I think the authorities bundles are tabbed. Yes, they are. Well, no, the application authorities are, the main authorities are not.
Okay.
Maybe that could be done overnight.
It will be done.
But yes, page.
Page, please. Could you please turn up page 215. I'm sorry, Supplemental Bundle Volume 1 first. Volume 1.
Yep, 215.
Page 215. This is the pleading before Mr. Justice Sheldon.
Okay.
You will see.
I've marked this as APOC 5, is that correct?
You will see causation and loss. APOC 5.
Yes.
The version before the first instance judge. Causation and loss. Lots of red text.
Yes.
This is the case on causation and loss that was put before Mr. Justice Sheldon, and it was all amendments, as you can see. There is some black text, but by and large, it is red text introduced in draft amendments that were put before the judge.
Yep.
If we now turn to the version that they seek to introduce before this court, Supplemental Bundle Volume 2, page 666, please.
Yes.
You should have at 666 the heading causation and loss in the top left-hand side of the page.
Yep.
And you can see that everything you were just looking at has been deleted, and extensive new amendments in green under the heading particulars of loss, if properly advised, in fact as a result of the advice given, extensive new pleading now on appeal in respect of causation and loss. These are not clarificatory amendments, they have deleted their previous case. And the framing of this as clarificatory of existing pleading is not correct. Now, resuming the narrative in the context of the amendments, neither test is satisfied. Let me start on the application to amend in a bit more detail. My Lords, we've provided you with detailed written submissions on this in Supplemental Bundle Volume 2. Tab number will not be useful. Page 482, please. Our written submissions start at 478. I'm going to go to 482, please.
Yep.
And I'll do this at a canter, but if I'm going too fast, please let me know. Paragraph 15, page 482. Conscious there's quite a lot of paperwork to shuffle back and forth as well.
Yeah.
You will see we refer at paragraph 15 to our letter, 21st of February 2023, intimating the strikeout ground on no causal nexus or outside the scope of duty or no loss. That makes good. I don't propose to turn the pages of the correspondence itself. I'll show it to you here. That makes good the point I was making earlier, that they had almost a year to get their house in order before we got to Mr. Justice Sheldon in early February 2024. Now, the response comes 4 months later, paragraph 16 of our note, just below. We get a letter from them back in June 2023 with an amended pleading. no explanation, we're just told this meets your case. We don't get the explanation until the 11th of August 2023, that's at paragraph 18. At the same time, in August, we get the second amended pleading. Mr. O'Doherty has kindly taken you through some of this history.
Yep.
Paragraph 19, we get APOC 3, the fourth version of the pleading, that's in September. We say none of these amendments cure the fundamental premise of your case. We issue our strikeout application. In the chronology, that falls on 21st of September 2023. As Mr. O'Doherty explained, the hearing of their application to amend met with our strikeout application was originally due to take place in late November. It gets adjourned to early February. In January, we get two further draft amended particulars of claim with various amendments. That's for APOCs 4 and 5, and then the hearing before Mr. Justice Sheldon in early February. And I note...
What was the ground for adjournment in November 23?
There had been, Mr. O'Doherty...
Late disclosure.
There was some disclosure that emerged, and they the claimants sought an adjournment. We didn't oppose. It was adjourned on terms, and then it was heard by Mr. Justice Sheldon over 3 days.
I referred to late disclosure. Presumably there wasn't actually an order for disclosure as such.
We'd volunteered some materials. Now, we note, my lord, in this note, and I'll give my lord the reference, paragraph 38.4 of this note, that there was, of course, an exchange of skeletons before the hearing before Mr. Justice Sheldon, and we identified a number of continuing problems with the pleaded case in that skeleton.
When did you send your skeleton?
The skeletons would have been served a matter of days before the hearing. I don't have the... We can find the exact date because the documents are actually before the court in one of the bundles. The claimants have produced one for themselves, for their part, the claimants have produced one in November, and then the claimants and the defendants produced the fresh skeletons effectively shortly before the hearing in the customary way. Because of course, at first instance, the skeletons tend to be produced a few days before the hearing, unlike on appeal. The 2nd of February, I'm told.
And when the hearing started on the 7th?
Yes. Can I add just two?
Weren't those points taken in correspondence beforehand?
Yes, I believe so.
That's not in your chronology.
I'd have to check that, my lord. I'd have to check that. I've answered too quickly.
Do we know what day of the week 2nd of February was? It's the 2nd of February 2024, isn't it?
Yes. The key point taken in the skeleton, of course, was that your claim is analytically flawed, which was the same point that was taken in the February the previous year. As your lordships will know, there were a number of other grounds of challenge, and some succeeded and some failed.
Yeah.
Now, can I add this by way of factual background? These were not pleadings put together in haste, even originally, my lords. These companies went into the control of office holders in or around July 2019. July 2019. Proceedings don't get issued until 2022. So by the time the proceedings are issued, the office holders have been in office for around 3 years. And by the time of the hearing before Mr. Justice Sheldon, they've been in office longer. And my lords, these are not short pleadings. This is not a situation where the claimants have tried to cram in a big claim in, say, the 25 pages that the commercial court typically offers. These pleadings run to 140 odd pages. So they had had every chance to plead their case. There was no ambush, no surprise about the points we were running, which had been flagged almost a year before and then repeated several times, including repeated in the witness statement in support of the strikeout application. My lords, there was no suggestion during the hearing before Sheldon, Mr. Justice Sheldon, that they wished to make further amendments. There was no mention of this at the consequentials hearing where he dealt with costs. There was no mention of this on application in the application for permission to appeal, whether to Mr. Justice Sheldon or to this court. And indeed, at the permission stage before this court, they produced 2 skeleton arguments for the permission stage. One of them served on the morning of the hearing, no mention of further amendments or indeed additional evidence. And so what's happened is that they've lost before Mr. Justice Sheldon. They then come before Lord Justice Dingemans on the PTA hearing, who's made further observations about problems with the pleading, but taken an interest in the scope of duty point of substance and granted permission on that basis, and then decided that he'll grant permission across the board because it's going forward anyway. And they've decided, having heard those observations, they should try and fix their case. And the problem with all of this is the problem identified in Qua and in Acasta and in Aylwin, which is it treats the first instance hearing as a dry run, and it treats the exchanges with Lord Justice Dingemans as a tutorial, and now we can try and prepare our case. That hearing before Mr. Justice Sheldon was 3 full days, if I recall correctly. It's right to say there was also an application to amend against the other defendants, but that did not occupy a great deal of the time. Certain trials in the High Court, my lords, take less time than the strikeout hearing in this case. It costs hundreds of thousands of pounds to argue. And we note, and I'll just refer you to our notes, paragraph 29.4, where we quote Lord Justice Dingemans on the compensation point, where he said to my learned friends, it may well be the Court of Appeal says you're too late. And we've included further quotes from Lord Justice Dingemans in paragraphs 30 and 31.
Sorry, where was that quote? 34?
In my notes, so it was paragraph 29.4 of our notes.
29.4, thank you.
He said, as I said provisionally, it seems to me that the current version certainly doesn't do this, and it may well be the Court of Appeal says too late. Now, I was going to address you next on the point that these amendments are substantive. This isn't clarificatory at all. There was no reference below to claims for compensation within section 26(2)(b), and they were raised for the first time in oral responsive submissions to the strikeout, oral responsive submissions on the strikeout. And again, not even an amendment.
So you started that sentence with there was no reference to claims for compensation in the pleading. That was what I was missing.
I'm sorry, I'm going too fast.
I thought there was a claim for an indemnity against...
There's a claim for an indemnity and there's a reference to section 26 of FISMA.
Losses arising from section 26, paragraph 177.
Don't seek to... That is what it is. There's no reference to compensation. And if the claimant's position is, well, we've pleaded it already, then it's my Lord Justice Nugee's point, well, if it's already in, you don't need your amendment.
Well, just so I understand, as things stood before Mr. Justice Sheldon, there was paragraph 177 talking about indemnity in relation to losses arising from section 26. But insofar as any losses were pleaded at that stage, presumably some were, what sort of losses were they?
What was advanced?
Were they return of investment funds?
It was return of investment. It wasn't compensation.
So 26(2)(a.
Yes.
I understand.
It's a point I made to Mr. Justice Sheldon in submissions.
Well, can I just... I think this is of some significance, so can we take a little bit more time over this? What I'm interested in is what loss was pleaded before Mr. Justice Sheldon. So can we just look at that? Because as you say, there's a very long pleading, and we get to 168, if LF had advised fully, properly and competently, and so on. The asset SPVs would not have lost the entirety of their investor receipts, and the claimants would not have suffered the significant section 26 FISMA civil liabilities which they have in fact suffered. Is that explained, what the section 26 liability is?
It's not. That is as far as it goes on section 26.
There was also 177 at page 166.
Absolutely.
Which Mr. Doctor referred to earlier on, and 241, he also referred to in the same terms.
Replicates
So
the
it's
same.
more the same.
Well, before you get there, 173,
173 is
it pleads figures,
It does.
and then it says that these figures are particularised in the schedule. Are those figures the amount received from the investors.
It is amounts received less the returns that were already paid to them within the context of the schemes. So that you're...
No, some of the early investors were paid the 10%.
It's a Ponzi scheme. That's how it works, exactly.
Yes.
And so they give credit for that, but there is no, as I read Schedule 3, I'm trying to find the page number for my words.
Do we have to Schedule 3? I don't think we do.
Maybe it's not here.
My pleading finishes at 727, I think. Unless it's in the...
But I think there's something, there's a document at 273 which I think is the relevant schedule. Summary, or at least a summary.
273.
This is a version of Schedule 3. I can't be sure whether it was the very same version that was before Mr. Justice Sheldon, but it gives you an idea of how quantum is expressed, or at least was expressed before Mr. Justice Sheldon. We can go through it quickly. I think it may be helpful in addressing my Lord Justice Nugee's question. Do you have it, my Lords? It should have some colour coding.
Page 273,
273.
an Excel spreadsheet.
Yes, my Lord. You have investor deposits. It's categorised by scheme, by location. Investor deposits, those are the amounts said to have been received. Obviously, I don't admit any of this, but we're using this for the purposes of this debate. Investor deposits, those are the amounts invested, date of first investment, date of last investment, whether the other defendants in this case, Metis, were involved in those transactions, and if so, how much was raised on their watch, if I can put it colloquially.
Yep.
Total investor funds raised, and then returns paid. Those are the 10% per annum that some investors would have received.
Yep.
And then you get a difference, investor loss.
And that's the 63 million.
And that's the 63 million. So there is no
And then-
claim.
And then some of that is statute barred.
Some of that, and that's in yellow. So there is no claim for compensation, whether under FISMA or otherwise. Certainly no claim under FISMA, section 26(2)(b). Now, that's the point on compensation, and I've shown you the point on causation and loss when I showed you the pleading earlier. There's a whole new case advanced on causation and loss, and if we also turn back, I'll just show you some other amendments within the version in Supplemental Bundle Volume 2. There are some also at page 615, Volume 2, 615, some new allegations of express or implied terms of retainers, which are additional. So a whole new case on causation and loss, a whole new claim for compensation within section 26(2)(b) of FISMA, and also allegations around express and implied duties. My Lords, standing back from all of that, no ambush, lots of time to prepare your case. They did amend their case to meet our arguments. That's the red that I showed you. And they said that that was enough. We went and argued for 3 days before Mr. Justice Sheldon, and we spent a lot of time and money doing so. The test the claimants have to meet, my Lords, is a significant one. It's amendments after the case has been decided. And they must justify the lateness, and there will be, as the Chancellor, Sir Geoffrey Voss, as the Chancellor was at the time, has said that the principles inquiry must apply with even greater vigour when we're applying to amend on appeal. Can I just quickly show you the authorities? The 3 cases are Aylwin, which my Lord Justice Nugee has already referred to. Let me start with Nesbitt and Acasta. It's Application Authorities Bundle, please, tab 6. You can pick it up at page 106 of the bundle. The numbers are extremely small in the bottom right-hand corner.
Yes.
you'll see the heading at the top of the page, the amendment issue. The relevant observations start at 41. The principles relating to the grant of permissions were already set out in Swain Mason and the series of authorities parties referred particularly to Mr. Justice Carr's summary inquire. And let me just pause there. If I can show you what was said in Qua, so that we can then see what the Chancellor was referring to when he said we have to apply it with even more vigour. If you turn back, my lords, to tab 5, you will find Qua, and it's page 83 in the small number at the bottom right of the group. This was not an amendment application on appeal. It was an amendment application shortly before.
3 weeks before trial.
Precisely. And it's paragraph 38.
Yep.
Please. And matter of discretion, that's sub A. When a very late application is made, is the correct approach is not that the amendments ought in general to be allowed. Rather, heavy burden lies on the party seeking a very late amendment to show the strength of the new case and why justice to him, his opponent, and other parties requires him to be able to pursue it. And then I emphasise E, gone are the days when sufficient to argue no prejudice has been suffered save as to costs. In this case, in any case, not applicable by the cost only in any event. F, over the page, incumbent on a party seeking the indulgence of the court be allowed to raise electing to provide a good explanation for the delay. I stress, in relation to both the evidence and the amendments, no explanation for the delay at all. And then much stricter view taken nowadays as non-compliance, no longer expect the indulgence of the court, and so on. So that's what the Chancellor was referring to. If we turn back to Nesbitt and Acasta, page 106 of the bundle.
This was after trial, appeal from trial, was
We're
it?
now after the trial and we're on appeal.
Yep.
Analogous to this case.
Well, except we haven't had a trial.
No, we haven't had a trial, I accept that. Court must, taking into account of the 41 balance the injustice, that was something that my lord referred to. Heavy burden on the party seeking a late amendment to justify the lateness and to show the strength of the new case. There's been no attempt to show that and why justice requires him to pursue it. Principles apply with even greater vigour to an amendment not made after trial. Now, I accept we're not after trial, but it must be right that it applies with even greater vigour after judgment when your claim's been dismissed. Otherwise, the finality of litigation is seriously at risk. And allow me to.
Well, I'll be perfectly frank, Mr. Sol. If it had not been for Lady Justice Arden's decision in Elwyn, I could see an argument that it is different at an interlocutory stage when you haven't had a trial to lose your claim than to lose a claim once you've had a trial and all the evidence has been called and so on and so forth. That's why I referred to Elwyn when in debate with Mr. O'Doherty, because that does seem to me, and he accepted it was binding on us, to apply the same rigour to our situation, which is where a claim has been dismissed under CPR 3.4.
I respectfully agree, if I may say so, and we've made that point in the note. The principles applicable post-trial apply by analogy with this situation. Of course, I accept that when you're balancing matters, it's different after a trial. Witnesses have turned up, there may have been disclosure, witness statements, cross-examination. It's different. But the core point is that the court needs to be very vigilant not to undermine the finality of the first instance process. And let me say this is a particularly extreme case, my lords. This is not a situation where someone's been ambushed by a late point shortly before the hearing, and they haven't had a chance to really think about it. They've been developing the point on their feet. We raised the point almost a year beforehand. It was then litigated effectively, ventilated in correspondence under the witness statements in support of and in response to the strikeout application. And they tried to amend 5 times by the time we got to Mr. Justice Sheldon.
I don't think the number of times they've tried to amend is really going to be determinative. You'd be in exactly the same position if they'd only tried to amend once.
I don't disagree, but they've had plenty of time. That's the key point, and they've taken the opportunity. If the court were to allow an amendment on the floor here, It is difficult to identify in which case it would not be permissible following a strikeout. And that's where we get to Lady Justice Arden in Aylwin at 41. At 44, I would add that the Chancellor in Acasta repeated what Mrs. Justice Carr said. At 44, he said the new approach to late amendments epitomised in Spain Mason would be set at naught if an amendment in these circumstances were to be allowed. And that is true here also. And so no explanation for the lateness of these amendments offered at all. The flaws in the case identified at an early stage. Plenty of time to get their case in order. And it's not in accordance with the overriding objective to allow these amendments and for broader reasons either. We had a heavy first instance hearing. My clients have had this litigation hanging over them for more than 3 years now. Most litigation would have concluded definitively within that time frame. I appreciate that all. It relates back, my lords, to events dating back to 2014. And it's not just legal time and resource in preparing and fighting a case, it's also internal resource. And it's a case, and as with any heavy litigation, that generates ongoing operational uncertainty and adverse publicity for the client. It is not fair on my client to face a claim that is constantly changing. There is no unfairness to the claimants in requiring to argue their case by reference to the pleading that they amended. And the hearing for Mr. Justice Sheldon wasn't a practice. And then can I make one correction to my note, which is simply this: the reference in paragraph 47 of our note to the case of Hague. We've cited the first instance decision. It should be a reference to the Court of Appeal decision. It's purely correction.
I've now lost where your skeleton for this application is. Where do I find it?
It was in Supplemental Bundle, Volume 2.
Page 494.
Yes. Thank you.
The reference, you have the right authority in the bundle, but the reference should be 2014 EWCA Civ 1609. Now briefly, my lords, the application to produce new evidence, it's lad and marshal through the prism of the overriding objective. And we do not accept, and we in fact reject the suggestion made that the overriding objective allows you to escape from lad and marshal territory and gives you some exit route. That is not the rule. Just applying the tests quickly, could this material with reasonable diligence have been available for the first instance judge? Yes, without exception, and with the exception of one single document which postdates the hearing, which is a progress report from the liquidators, but it is in the same category as some of the other documents which they seek to produce, which are other progress reports which predate the hearing. So nothing turns on that. With that one exception, they all predate the hearing below, and in some cases by several years. I've explained that they did serve evidence, 2 rounds of evidence below. No explanation for the lateness. And these are documents they've always had. And we don't accept with respect that they are merely clarifying claims by investors. No such evidence at all was put before Mr. Justice Sheldon. That's test 1. The second test relates to the probative nature of the material. And my lords, here the claimants are in even greater difficulty. It has been said by Mr. Armstrong, the witness who gives a statement, and in submissions by the claimants, that this information is there to clarify or explain or put flesh on the bones of the liabilities said to be owed under FISMA to investors. That is not what the documents show at all. What they show are investors putting in claims for debt or tortious rescission. There is no reference in any of these documents to these schemes being a collective investment scheme under Section 235 or to a claim under Section 26 of FISMA. We can look at a couple of examples if it assists. supplemental bundle volume 2, please. I won't take long. The exhibit is at, the numbering here has become a bit difficult to read, but if you can find 455, at least it is on my versions.
Yep. Exhibit RA1.
Exhibit RA1. This is the material they seek to introduce. 456 and 457 is an example of a proof of debt. And my lords can simply look at it. Total amount of claim 82,000 is the loss plus interest is against box 3 on the left hand side. That was the initial payment for lodge at Afan Valley. And then there's some narrative text on the right. I'm sorry, I don't fully understand this form. If you need more info, you may need to email me to clarify the English detail what's required. And the investor explains that she's hoping to make a recovery. The suggestion that this is evidence of an investor submitting a claim under FISMA.
Yes, but you have to imagine how this might develop into the worst of the trial. It doesn't take much imagination to appreciate we'd get to section 26.
Well,
The fact that this person is asking what is a lien doesn't really help the
no, I take the point, but let me refer my lord to another example, which is at 476 of the bundle, where what you see here are contractual claims, and we'll come back to some of this in the hearing of the appeal itself. But the investor here is asking for payment of the contractual returns.
Well,
Now,
this is not a proof of debt.
No,
This
that-
is something
that-
called an investor
That's the
questionnaire.
difference type. I accept that.
And if you're asked the question, what were you promised, and whether it's being paid, it's not surprising if you answer it.
So I see that. But the point I'm making is when it's being suggested we've been subject to claims under FISMA, it's not correct. I don't put it beyond that, but I'm asking what is the probative value of this material? And in my submission, very little.
Okay.
Those are return of investment documents, are they?
That's what was described as an investor questionnaire and the
Yes, but they're relating to the return of the investment.
the sums that the investor was writing down. That's my
Yes,
understanding.
well, that has been pleaded.
No, the claims. I think there was a semantic misunderstanding between us. What was being referred to, as I understood it in that investor questionnaire, were the contractual returns.
Oh, I see, sorry.
And then my
10% and the 12%. Okay, sorry.
and that's not a FISMA claim; it's a contractual claim. My lord, we finally on the question of the material, it's obviously been redacted. We don't know who the investors are. I can't take it any further because I don't know who these people are or what their position is. But my lord, no explanation for the lateness. Documents always in their possession. Now, my lord, can I just close with one correction, which is my lord's asked of Mr. O'Doherty. Did Mr. Justice Sheldon assess the strikeout on the basis that the amendments before him were in, and only then consider afterwards in the alternative whether they should be allowed on a discrete basis? The answer to that question is yes, and he explained the approach he took at paragraph 36 of his judgment, which was to take the pleaded claim at its highest as put, and then assess the strikeout on that
Yes.
basis. My lords, unless I can assist you further, those are my submissions.
Thank you very much. Thank you. Yes, Mr. O'Doherty.
Well, several points in reply. These pleadings have been characterised as not having been prepared under time pressure, and it goes to the delay point, and that's simply wrong. There were limitation issues in April 2022. By that stage, the companies had been in liquidation, administration, and then liquidation for some considerable period of time. Could I take your lordships to page 444, supplementary bundle, of the evidence box of the claimant's application, where this point is raised. in order to facilitate these claims, the liquidators required funding and after the event insurance.
Yep.
Funding and after the event insurance was not obtained until shortly before the 4 months expiring in August 2022 that the claim was issued. So the pleadings were drafted under considerable limitation pressure. And it does go to the issue of delay, because if they had not...
Where do we find this on 444, the reference to the ATE?
I do beg your pardon.
Is that paragraph 3?
3.
Paragraph 3. After the event insurance was only obtained on the 3rd of August 2022.
That's, you're telling us on instructions. It doesn't seem to be.
I am.
Yes. Thank you.
Now, why is this significant? We say it's significant because a large portion of the argument with respect to the content and the way in which the claims are pleaded would, in the ordinary course of events, without such limitation pressure, have been dealt with in pre-action correspondence.
Is your point that the particulars of claim went in on the 10th of August?
Yeah, they were served on the 10th of August. So they were pleaded several months before.
I see.
But under that time pressure. So it's the way in which Mr. Salt has characterised it, as these pleadings were not pleaded under pressure. They were pleaded under very significant time pressure. And it's within this context that the pleading of the indemnities under Section 26 were pleaded in the way in which they were. Mr. Armstrong, one of the joint administrators, is in a position that as well as practitioners in these types of scenarios are very often that they do not know the full extent of the losses at the point at which they are required under their professional duties to embark upon litigation of this nature. And that is the background against which these losses are pleaded. The amendments that are put forward clarifying and expanding out the case with respect to how the losses are pleaded by the very nature of the arguments that are before the court in the appeal, which is the scope of duty in the next. These points in the ordinary case of litigation could easily have been dealt with in pre-action correspondence, but they weren't. And in order to ensure that the claims are not lost in liquidation, the indemnity point at 177 was pleaded. And we say, and it's at page 677 using APOC 6, we say it is clear from the face of the pleadings that this is a wide plead for an indemnity. The claimants were doing the best that they could at the time at which the amendments were made with respect to the losses as pleaded. Now, my lords, when I took the court to Mr. Armstrong's evidence, and in the interest of time I jumped straight to paragraph 15. But it is right, perhaps at this juncture, to deal with the earlier part of his evidence, where he sets out the difficulties that he is in. Paragraph 9 on page 452.
452.
My lord, yes. So it's the second page of
Thank
Mr.
you.
Armstrong's witness statement.
No, I don't think it's 452. Which page is it?
My lord, it is in the version that.
Which paragraph?
Paragraph 9.
That's what I thought. That's the
Oh, I see.
Final-
Yes.
the
Thank
final
you.
paragraph.
Yes. Thank you.
So it's the losses due to compensation claims are dealt with from paragraph 5 onwards, my lord.
Yes. And what do you want us to look at?
if you look at paragraph, having set out what he seeks to address, if you then look at paragraph 9, he sets out the reasons why he is not going to be necessarily going to be in a position to do anything other than plead an indemnity.
Okay.
And my lord, I say this goes directly to the delay point. If your lordship must consider that these are late amendments, then looking at the test inquire, paragraph 38A that Mr. Soul took to, your lordships have discretion to allow the amendments in and discretion to allow the evidence in.
Yep.
And we say that on the basis that there is an existing pleaded case that pleads the case with as much particularity as can be done, that your lordship should exercise the overriding objective in favour of the claimants in allowing both the evidence and the additional pleading in a process.
Okay.
Well, those are my submissions.
No, thank you very much. What we'll do, we'll rise. We don't guarantee to give you an answer, but we'll see where we are. Don't leave court. We won't be very long.
You have to sit very patiently, James. Sometimes it's nice to just have steady. But you get the benefit of having seen how they go.
Yeah, when I said
Well, keeping your head down.
seconds at the start, like
able.
Thank you both very much for your very helpful submissions. We have decided that we will refuse the amendment to the particulars of claim, and with it refuse the admission of the new evidence of Mr. Armstrong. Reasons will appear in our judgments in due course, but what that means for the rest of the appeal is that the question whether Mr. Justice Sheldon was wrong to strike out the action will be determined on the version of the pleading that was before him, which we understand to be APOC 5. Mr. Pickering, I'm afraid we've taken up rather more time than expected. Are you going to be able to get through your submissions by 3:45?
My Lord, I will do my best.
Yes.
My Lord, perhaps I can set out the proposed outline of my submissions.
Yes.
First of all, I propose to give a brief summary of the claimant's case, and then to go through each of our grounds of appeal in turn. First of all, ground 1, which is in short the no loss point.
Yep.
That involves the consideration of the Stanford case. I'm then going to go straight to ground 3, if I may, which is the compensation point.
Yes.
And then I'm going to return to ground 2, which is the scope of duty point, which will involve submissions as to why we say the judge was wrong to place such heavy reliance on Saddington, and perhaps more importantly, why in our submission he should have focused on the Manchester Building Society case.
Yes. Thank you.
My Lord, starting then with a brief summary of our case, and we appreciate the court will be familiar with the broad background from the papers, but we hope that a brief run through some of the key facts and some of the documents may assist the court on this appeal. The court would have seen that the claimants are all SPV companies, all now in liquidation.
Do we need to distinguish between them at all?
For present purposes, my Lord, no.
No.
Those companies were set up as part of a series of investment schemes in which investors would buy an interest in a room within, for example, a hotel or a care.
And it was sold on the basis they would actually get a legal estate, or get a lease, a sublease of the room.
Yes.
Yes.
It was a sublease, and the general position was that there would be each year some form of return.
A guaranteed 10% return, which seems very generous, but there we are.
Lord, yes, one may say ambitious or generous. And my Lord, there was a potential buyback provision after a certain period of time, often 10 years.
In which not only would you get your money back, you'd get a 12.5% uplift.
Lord, yes.
Yes.
So it was indeed a very generous scheme. But your Lordship is absolutely right. Under the terms of the investment, the investor, once he or she had parted with their money, in return received a contract in terms of the sublease, a legal estate, and certain contractual
And some of them, I think, did, but some of them paid their money and never got it.
Lord, yes.
And never got to a state. What happened to those who did get legal interests? Why have they still not got valuable assets?
Lord, some of the assets have been realised. Lord, credit is given for that in the various schedules.
Right. Okay.
But it's not a great deal. It's, if one looks at I think it's Schedule 3. We've seen the monies going out, and next to the various numbers of the schemes, we can see monies coming back in, because there were some of the assets involved property which existed, some were off plan, some were yet to be bought. But there were some assets which were realised, and credit has been given for those.
And are those, I mean, this probably doesn't make any difference at all, but are those the proceeds of a sale? Are they allocated to the particular investor whose room it was, or do they go into the general liquidation pot?
The latter, my Lord.
Okay.
It seems to the extent there are proprietary claims, it would be different. But my understanding is that the monies which have been realised do not actually give rise to proprietary claims.
Even if you had a sublease?
Well, Lord, if there's a sublease, a proprietary claim, so that would be outside of the liquidation.
I see. Okay.
In terms of the monies for which credit has been given, these various general assets and sales which have been achieved, these currently fall in the general liquidation estate. And my lord, there were numerous schemes, and generally, not always, but generally, for each scheme there was one SPV, which owned the underlying property in question and which contracted with the individual investors.
Yep.
So to give an example, if an investor came along to invest, say, £100,000, and my lord's pausing there, generally the investments were that sort of nature. We're not talking about multi-million pounds, it's smaller investors, roughly that sort of sum. If an investor came along wishing to invest £100,000, the investor would contract with the SPV, pay their £100,000 in general, not always, and in return have the contractual rights under the sublease or whatever, and of course certain statutory rights. And my lords, importantly, all of this has to be considered in the context of FSMA, the Financial Services and Markets Act of 2000, the provisions of which are policed by the what is now the FCA.
Yep.
Well, given the nature of the schemes,
When were the schemes up and running?
2018, the schemes under consideration, but the forerunner from 2016, I think 2016. My lords, you may have seen there was an individual called Gavin Woodhouse.
Yes.
He set up the original schemes in 2016, went into partnership with someone called Mr. Forster. They then went separate ways and they split certain existing schemes and started new schemes.
Those are the MBI schemes.
My lord, yes. My lord, yes. So,
When you say 2018, that's referable to the MPD schemes.
My lord, yes. And the majority of the schemes under consideration here are schemes, the NPD schemes. There are some which predate. For what it's worth, they are largely limitation barred. But the schemes...
So the MPD schemes, that's Mr. Woodhouse's once they've split.
My lord, yes. After the split, there are the NPD companies, and Mr. Woodhouse also took some of the MBI companies, which are materially identical.
Yep.
And my lords, right from the start, back in 2016, before the split, and again after the split in 2018, there were always concerns as to whether the schemes might fall within the statutory definition as what is known as a collective investment scheme, CIS, within the meaning of FSMA. And my lords, the significance of this, it's fairly obvious, but it's worth restating for the purposes of this appeal. Under FSMA, if the scheme is a CIS, it can only be operated by an authorised person. Again, as defined in FSMA, and I'll come to the definitions in a moment.
Well, I think this is all common ground, isn't it?
Well, it is.
So the companies were operating these schemes. None of the companies were authorised under FSMA. So if the scheme was a CIS, then it was unauthorised.
My lord, yes.
Do we need to know any more than that?
My lord, no, apart from the motivation of those behind the groups, because they consistently sought legal advice as to whether they were or were not CIS.
Yes. Presumably, is this right? There's not actually been any formal determination whether the schemes were CISs.
My lord, correct. It's something which we plead. In the present case, that's correct. We plead that they are, and I think it's right to say that the defendant has been very careful in not accepting it for the purposes of the summary judgment strikeout.
You assume you're right.
Yes, and I think it's right to say that the defendant hasn't formally accepted that.
Yep.
And I should say, my lord, in separate qualia proceedings, related proceedings, they have formally been found to be CIS. Those are related.
What did you describe them as?
Qualia.
Qualia.
After the break from MBI.
That was Mr. Forster's
my lord, yes.
successor.
My lord, yes.
Yes.
And then my
And
two-
who's decided that?
Well, can I take
Is that the FCA has intervened or something? Or?
Lord, can I just turn my back? My lord, we can find the authority. It's the FCA versus Forster,
Yeah.
and it was a judgment of Mr. Simon Gleeson, Casey sitting as a deputy High Court judge.
Okay. And you say that your schemes are indistinguishable, but that's not formally been decided in relation to your schemes.
My lord, correct.
But we proceed on the assumption that your pleading case is correct.
My lord, yes. And certainly what is highly relevant for these purposes is that from the very start, from 2016, and again when NPD took off in 2018, Mr. Woodhouse consistently sought legal advice, seeking confirmation that the schemes were not CIS.
Yep.
And we don't suggest that he did so through any altruism or moral duty, but for pragmatic commercial reasons.
You wanted to be able to promote them.
My lord, yes.
Yep.
The FCA were policing all such schemes, and if they were non-compliant, the FCA there's a serious risk they'll intervene. And also, and again, it's demonstrated in the statements of case, investors, groups of investors would consistently seek reassurance, and so advice that the schemes were not CIS and therefore were not, also were compliant, again was an important part of the model of NPD and indeed its forerunner.
Yep.
In terms of the statutes, the key feature of this is section 26.
Yes.
Your lordships have seen reference to that, but perhaps I can invite the court to look at that. It's the opening authority in the main authorities bundle. That's page 3.
Yep.
In fact, the first section is section 19, which is the general prohibition that no person may carry on irregular activity unless authorised or exempt. And section 26 is important. An agreement made by a person in the course of carrying on a regulated activity in contravention of the general prohibition is unenforceable against the other party.
Yep.
2, your lordships will note this, but again it's worth emphasising 2 things. The other party is entitled to recover A, any money or other property paid or transferred by him under the agreement, and B, compensation. So we note from the defendant's skeleton, they say there's an election is required. I'll come on to compensation later. That involves a consideration of section 28. But our primary submission is that the automatic position, unless an investor positively choose otherwise, is as in section 26(1)(a), and that agreement is unenforceable against him or her.
Yes, but saying it's unenforceable doesn't mean that he can't enforce it.
Well, yes, only as against the investor.
So I can see why it might be thought that this section gives him a choice. Suppose I'm an investor, I put £100,000 into an unauthorised scheme, but actually it's standing to my credit at 120. I'd rather have what's promised to me under the scheme than get my money back. So I have a choice whether to seek to enforce the contract and get to what's promised to me, or to effectively exercise a statutory right of rescission and claim it back. Why is that not an election?
Well, it is, but it's not an election at large. For example, after sometimes a successful party may have a choice between equitable accounting or damages or an account, for example, and it's at large as to what the position is, and so the successful claimant has to positively elect between 2 choices, and until he or she does so, it's at large. Here, there is an election, but the starting position is unenforceable against him or her.
Yeah.
Well, perhaps I can skip down to section 28. It's a few pages down. In section 28, it's page 10 of the bundle. Agreements made unenforceable by section 26.
Yep.
And this section applies to an agreement unenforceable under section 26. The amount of compensation recoverable as a result of that section is the amount agreed between the parties or determined by the court. 3. If the court is satisfied that it is just and equitable in the circumstances of the case, it may allow the agreement to be enforced, or money and property paid or transferred and the agreement to be retained. My Lord, 7. If the person against whom the agreement is unenforceable, i.e. the investor, elects not to perform the agreement, or as a result of the section recovers money paid or other property transferred by him under the agreement, he must repay any money and return any other property received by him under the agreement. So, my Lord, the investor can't have his or her cake and eat it, quite clearly. But, my Lord, the starting position, there is an election, but it's not at large, it's unenforceable against the investor. That's the starting position. Now, my Lords, as I've said, the SPVs therefore needed advice, partly to keep the FCA at bay, and partly to encourage and reassure investors. And my Lords, the key, the crux of the factual case is that Lupton Fawcett, the defendant, was instructed by the group companies, including the SPVs, on numerous occasions over a period of several years, and gave advice. In short, however, it's the pleaded case that at no time did they advise that the schemes were unauthorised. Or
But they were specifically asked about the CIS question, or
yes.
what was their retainer to advise on whether it complied with FSMA? What was it?
My Lord, in a nutshell, it was whether they were CIS or not,
Yes.
and therefore FSMA compliant or not. In
So
fact,
this is not a case where it said a solicitor's asked to advise about something else and should have drawn something to the client's
well, correct,
attention.
it's not that sort of case.
Not that sort of case.
Specific express instructions, and I'll take your Lordship some key passages which are relevant to this appeal. Are these CIS or not?
Yeah.
And in fact, in terms of the retainer, we say it's actually wider than that, but that's the nub of the retainer.
Yep.
And in short, at no time did Lupton Fawcett advise that they were CIS or that there was a serious risk that they were CIS, unauthorised CIS. At no time did they advise that if they did turn out to be unauthorised CIS, that section 26 would bite, since they would become immediately liable to repay the investment monies plus compensation.
Yep.
And at no time did they advise that because of all of this they should stop receiving investor funds. My Lords, on the contrary, as the statement of case demonstrates, they gave positive advice. In other words, that the schemes were not CIS. Advice which they allowed to be shared with sales agents and investors. My Lords, this is perhaps best demonstrated by taking the court through certain matters in the amended particulars of claim.
Yep.
My Lords, I'd invite the court to go to APOC 6, which is the one which is no longer in play. Some of the material, how I would paraphrase it and describe it, it's the sort of material which one would put in a statement of case, a defence is received, and then material goes into a reply. Now, the APOC 6 itself, it shows, one can clearly see what was before the court. And
My lord, I'm sorry, I hesitate to intervene, but we've just had an hour or more on
I'm going to let Mr. Pickering show us what he wants. It may or may not be helpful to us, but I think I'm going to let him argue the case he wants to. I'm very conscious that this is something we've said is not how the case is to be argued, but if he thinks it's helpful to show it to us, I'm going to let him do so. Yes.
Lord, I can assure the court that I will, in terms of what's pleaded, I accept, of course, I can only rely on the material in red. My Lord, the document starts at 585 within the supplemental bundle.
I've got it at 583. Maybe I'm wrong.
It's 583.
Yeah.
It starts. And just by way of background, this is the useful summary, I hope, as to the background of the schemes 1, 2 and 3. The MBI group and NPD group promoted and operated the schemes.
Yep.
My Lord, at 616, we have the subheading MBI Consulting. And my Lords, to explain why this is relevant, this is in relation to MBI, and in short, advice was sought before the NPD group was set up. When the NPD group was set up, the Lupton Fawcett relied on the earlier advice. So this advice is relevant to the advice later to come. And you can see at 86A it's in red, so it's within draft amendments which were before Mr. Justice Sheldon in February last year.
Just a matter of interest, do we know what MBI stands for?
Well, I don't.
No. Okay.
I'm not sure if anyone outside the court has any idea, but the short answer is we don't know. So 86 A, in February 24, MBI was concerned as to whether or not it was in breach of FISMA. Lupton Fawcett was instructed to seek counsel's opinion and to advise on the issues as set out on these metrics of claim. Then we can go on to 86B. And reference is made to Mr. Green of counsel.
Yep.
And my Lord, just to fit into the later procedural context, the claimants were aware that there had been some advice, but it wasn't disclosed. I won't go into the background to that. But shortly before the first hearing of the strikeout application, it was disclosed, resulting in the adjournment.
Yes.
So this material came out as a result of the Green documents, Mr. Green documents, which were produced late 2023. And we can see at 86B, on February 2014, Lupton Fawcett instructed Mr. Tim Green of counsel. He was asked to advise on a comprehensive series of issues concerning the legal, regulatory and commercial implications surrounding the question of whether the MBI schemes were CIS, including Mr. Green considering the scheme documents for 2 sample investment schemes. Well, Lord, we can probably skip down 86D, we can see the documents that we saw.
Yep.
E are the issues, the questions he was asked to advise on. But 86F, pursuant to the instructions, Mr. Green provided a comprehensive and wide-ranging written advice in which he confirmed in clear terms that the MBI schemes on which he was being asked to advise were likely to be CIS. In particular, in a written advice, he advised as follows.
Yep.
And in short, they were CIS was a considerable risk as such. My Lords, we can probably then skip for present purposes to 86N, which is at page 621. It's Mr. Green's second advice. It's now March 2014. And a conference was held with Mr. Green, with Lupton Fawcett and representatives of MBI. During that conference, Mr. Green's first advice was discussed and how the MBI schemes could be designed so they're unlikely to be CIS.
Was his advice provided to the client? His written advice?
My lord, I assume yes.
I mean, normally it would. If you instruct solicitors to get an opinion from counsel, you normally expect to see the opinion.
Well, I assume yes, not police, because we see in 86N that there was a conference
Is that
in
a
which they
conference?
discussed
Yep.
the first advice. So I assume yes.
Okay, thank you.
So we have a conference where Mr. Green has given quite clear advice that there was a considerable risk, his words. A conference is arranged to discuss what they can do so the schemes are not CIS. And he then produces at the end of 86N a second written advice, 13th of March. And we can see what, in short terms, what he advised then. Risk of being CIS. Given that MBI did not intend to apply for FCA authorisation, and they have to consider the risk. There are various features which had to be considered. Advice there. Well, we then go to 87, and this is obviously the original current text. Then in September 2014, the FCA sent a letter to MBI in which it expressed its concern as to whether the schemes were unregulated CAS being promoted and operating conventional FISMA, a warning of the significant civil and criminal implications. And 88, shortly after receipt of the above letter, MBI Consulting instructed Lupton Fawcett to advise and correspond with the FCA in response to the FCA letter. My lord, it's received advice, it's not positive, they had to make some changes. They then, no doubt it wasn't a surprise, receive a letter from the FCA expressing concern, and so they go back to Lupton Fawcett seeking advice. We can probably go to the advice to deal with retainers. If we can go straight, my lords, please, to 94.
Yep.
(94A), it's page 627, under the subheading performance. And again, this is text which was before Mr. Justice Sheldon, because it's in red. And in 94A, following Lupton Fawcett's receipt of the SCA letter, LF took instructions from, that's Mr. Woodhouse, Mr. Coburn and Mr. Forster in relation to the content of the and issues raised in Mr. Green's advices, the risks that the MBI schemes were very likely to be CIS, and what could be done to minimise the risks that the MBI schemes were CIS. So meeting in October, attended by Andrew Lindsay and Darren Carter of Lupton Fawcett, detailed instructions. Despite taking instructions, none of the matters raised by Mr. Green were addressed properly or at all. And in 95, this is a matter which was drawn to Mr. Justice Sheldon's attention. On the 30th September 2014, Lupton Fawcett wrote to the FCA giving an outline response and seeking an extension of time to take special advice. And then on the 24th of October, this is the back to the black text, and in further response, LF wrote to the FCA setting out a series of reasons why the MBI schemes did not fall within the statutory definition of a CIS within section 235, and therefore why the threatened civil implications did not arise. My lords, the next important...
Civil implications, were they civil penalties?
My lord, yes.
No, okay, thank you.
Fines, in other words, my lord. 97, again, mostly original text, but the rest was before Mr. Justice Sheldon. The factual explanation given by LF, that's given by LF to the FCA, as regards the operation of the schemes was materially incorrect. LF ought to have known this from the instructions provided by MBI Consulting, from his own analysis of the scheme documentation, and from the advice provided by Mr. Green. And 98, based on the materially inaccurate description and factual explanation provided by LF, On the 29th of January 15, the FCA replied stating it was satisfied with the explanation provided, and as a result no further action will be taken. So, my lords, one of the purposes of getting advice, as I say, it wasn't through Mr Woodhouse's altruism or moral duty, it was to keep the FCA off his back, and it worked. But it does seem that in doing so, Lupton Fawcett wrote a letter which largely ignored Mr Green's clear advice that there was considerable risk of schemes of CIS.
Well, there's a difference between saying there's no doubt they're serious and that there's a serious risk they're CIS, and if advice from counsel is the latter, as long as you don't misrepresent the facts, you can put forward whatever arguments you think are properly open to you. The allegation is they misrepresented the facts, and that's a different type of allegation.
Well, yes, and I would need to go into an exploration of that letter, which is probably not
necessary
for today.
for today.
Well, 99, so page 629, by mid-late 15, the MBI group sought advice on making a preemptive application to the FCA, a process which was not possible, to assert that the schemes were not CIS. It was for this reason LF was instructed to provide specific advice and seek further counsel's opinion. In paragraph 100, based on the apparent ongoing concerns that the schemes might fall within the definition of a CIS, LF instructed Professor Andrew Magee of counsel.
Yeah.
LF did not instruct Mr Green, notwithstanding the extensive advice he had previously given, nor did LF provide Professor Magee with either of Mr Green's written advices on the same instructions. And 101, Professor Magee advised the schemes did not fall within the definition of a CIS as set out in section 235. We then, at around this time, have the split. Mr Woodhouse forms the NPD group and Mr Forster goes off and forms the Collier group, an MBI split between them. And at 102, we see under the subheading Professor Magee's second opinion, LS advice. Then 102, in April 16, LF was instructed to advise NPD and the various SPVs for preemptive clearance. Said it couldn't do so but should get further opinion from counsel. In 103, an NPD instructed LF to obtain such an opinion, and again we see the text in red. They did not instruct Mr Green, nor did LF provide Professor Magee with either Mr Green's written advices or copies of the supporting documentation.
We've read that in 100. Same point again.
My lord, it's the same point for his second opinion. So Mr Green was given
Okay, I beg your pardon.
was given detailed instructions and lots of
I
documents.
made a mistake, sorry.
And Professor Magee wasn't either told about Mr Green's opinion, nor was he given the supporting documents. And again, in short, Professor Magee says that he doesn't believe the schemes to be CIS. 117. The various dealings, but we're now into 2016. At this time, this is page 635. At this time, LF as a firm was particularly familiar with professional risks involved in advising on suspicious investment schemes. In November 16, a former partner in LF, Stephen Pickard, was jailed for 8 years for false representations and concealing criminal property in relation to inducing investors into a Ponzi scheme investment that had been promoted and operated in 2010-11 at a time when he was a partner in LF. My lords, if we go to 637. And I referred to one of the motivations being to keep the FCA off the SPV's back. The other motivation to which I made reference was to reassure investors. And this is just an example at 123. At around the same time as these internal concerns were being raised, potential investors were seeking clarification on the regular implications of the structure of the schemes. And in February 17, queries were raised by TQPL on behalf of potential investors, their investment group, over certain aspects of the schemes. they had been shown Professor McGee's opinion, and subparagraph 1, the paragraph in Professor McGee's opinion in which he had stated the reason that he was of the view that section 2353 of FISMA did not apply was because no part of the initial sum which each investor pays to the landlord to acquire his lease is used to purchase the property or to fund the construction. Something which, as TQPL pointed out, was in fact the case for the schemes operated by NPD Group and had been the case from the very start. And the investors were seeking confirmation that Professor McGee had received the scheme documentation in exactly the same format as they were currently in, and also containing a request to see the original instructions to counsel. So the investors are, some of these are sophisticated investors, they've seen the documents, they've seen Professor McGee's opinion, which gives a green light, and they're not convinced, so they go back. Paragraph 124, Mr. Warner Reed, and Mr. Warner Reed is one of the partners in LF. He followed up with an email to Mr. Woodhouse stating that on reviewing LF's files, he had come across an advice by another counsel, Tim Green, which seemed contrary to Mr. Andrew McGee's. Mr. Warner Reed asked if GLW could shed any light on the position, a request which should have been but was not followed up. In an internal email from Mr. Lodge to Mr. Warner Reed, it was noted that in preparing his various opinions, Professor McGee had not seen and had not requested the underlying scheme documentation. 125, there was then a further email from TQPL, the investor group, stating that on their analysis the hotel scheme was a CIS, and given that Professor McGee had not seen an adoption, a further opinion on the matter was required. We can then go to 128. So in short, because of various investor pressure, new counsel was instructed. In May 17, instructions were sent to specialist counsel Oliver Assison, now Oliver Assison Casey, together with an outline explanation of the schemes from NPD's group. Detailed questions. 130. In June 17, Mr. Assison advised in a telephone conference in which further information was sought. There's no documentary record of the advice given by counsel. 131, same again. 132, whilst it's not precisely clear what advice Mr. Assison gave at this stage, it's clear that Mr. Assison was not prepared to advise that the schemes were not CIS. Reasonable inference that he had concerns. Also, I think we can go straight to 137. And there were further exchanges with Mr. Assison. July 17, Mr. Assison sent an email to Mr. Warner Reed pointing out the details of the arrangement, explaining it differed from those A, discussed in conference with Mr. Warner Reed, and B, set out in the letter to the FCA, which LF had sent in 2014. And Mr. Assison set out his understanding of the factual position which he was advising, inviting comment discussion, ahead of producing advice. In 138, Mr. Assison advised in writing the schemes would be considered CIS and the arrangement would need to be substantially altered to bring them outside of the CIS regime. Mr. Warner Reed of LF forwarded advice to GLW, commenting the contents do not make good reading and suggesting another conference with him to see if there's a way through this. And at this stage we note that LF did not provide any advice to NPD or the SPVs on how to deal with the issue. In particular, they didn't advise them, one, to cease trading, also to cease raising any further investment, or suspend the training, or how to deal with the substantial sums that were being raised. I think we can now go, my lords, to paragraph 146. In between there are various other instructions of counsel. But for present purposes I can go to 146. Page 645. So in September 27, Ms. Herndon, also of counsel, she advised by email that the references to Mr. Warner Reed and LF on the NPD group website ought to be removed. Mr. Warner Reed had not been appointed as statutory director in the company's NPD group, but was referred to on the NPD group website as a member of the NPD operating board. And 147, on the same day, Mr. Warner Reed emailed GLW asking for his name to be removed. On the 3rd of October, follow-up was sent noting his name was still there. His name was removed. Nevertheless, he continued to serve as a member of the NPD operating board, and they continue to refer to him in professional literature. 148, well, this is an important section in terms of question of duty and the scope of the duty. The reinstruction of Mr. Asserson. In October 17, Mr. Asserson was reinstructed and was sent copies of an amended lease and sublease. Mr. Warner Reed confirmed to Mr. Moore that he had instructed counsel on Mr. Asserson's brief opinion on the matter, and that clearly the intention is to get to the point where this is not a CIS. 149, for the avoidance of doubt, the above communication was an express acknowledgement by LF that in their current form, the various schemes were indeed CIS. 150, on the 10th of October, Mr. Asserson advised in telephone conference, following up with further detailed queries in relation to the new scheme documentation prepared by LF. Mr. Asserson's advice was not forthcoming until there had been a series of further email exchanges between him and LF. By 30th of November, Mr. Asserson was in a position to advise and sent an email advising, in summary, that although the amendment strengthened NPD's group position, there remained a material risk that the arrangements would be deemed as CIS. Lord, we say this is rather an extraordinary exchange. On the 30th of November, Mr. Warner Reed replied to Mr. Asserson stating, "I'm somewhat confused. You state it appears likely that the position will be strengthened by the amendments to the documentation, but there remains a material risk that the arrangements will be deemed as CIS. We have had a number of telephone conferences in which the documentation has been amended in accordance with your advice, so the arrangements are not deemed as CIS. You were specifically instructed not to draft a note if this was the conclusion. You were also instructed to pick up the telephone to me to address any issues if this was the conclusion you were coming to, in order to see if those issues could be overcome. This is really disappointing." And then subparagraph 2, new advice to GLW. In light of counsel advice, I advise you become FCA regulated. Well, we say that's an absolutely remarkable exchange, where clearly it's expressly seems to be LS position that if it's good news and these are not CIS, put it in writing. If not, don't put it in writing and pick up the phone.
Well, pick up the phone and see if the issues can be addressed.
My lord, yes.
Anyway, he did tell
Lord,
Mr. Woodhouse that here's the advice: you should become regulated.
Lord, yes.
Yeah.
There's no advice though saying, given this advice, you should not in the meantime continue taking investments.
Yeah.
And no advice as to what should happen to the monies which they already have. Lord, we then have 154. Notwithstanding LF being aware of the serious corresponding risks and issues that arose from so doing, LF allowed an inappropriately close relationship between one of its partners, Mr. Warner Reed, and Mr. Woodhouse and the NPD group. We refer there to the consultancy agreement and his remuneration there. And 155, rather than giving independent advice to the lead companies and addressing the multiple issues, and LF's clear advice that the schemes were CIS, LF's focus was instead to obtain alternative advice that the schemes were not CIS. Well, this continued. This was in that was in December 17. But this continued until June 2019. And again, my lords, it's possible to go through various exchanges And at no stage, in short, did LF give the advice that because these are CIS, or the serious risk, you should not continue taking investments, let alone of pointing out the risks of doing so, whether in the terms of Section 26 or otherwise. My Lord, this continued until June 2019, when a number of dissatisfied investors applied to the court for administration orders. And until then, investors were being paid enough to keep them happy. But in 2019, the companies were put into administration and later into liquidation. But as your lordships have seen, for several years the group was able to keep the SC at bay and attract significant investment, some £68 million from relatively small investors, average sum being roughly £100,000, and it's these investors who form the vast majority of the creditors. My Lords, continuing with the narrative, the SPVs then, acting through their respective liquidators, formed a view that there were potential claims. But because the companies in liquidation had been left with zero cash, there were funding issues. Mr. Doherty touched on that in the
Yes,
the application.
of course, very commonly the case.
My Lord, it is indeed. And so by the time that funding issues were resolved, the SPVs and liquidators were facing limitation. And we accept, less than ideally, we accept that. In April 2022, the present claim was issued because of limitation against Lupton Fawcett and another firm, Edis, without an opportunity for pre-action correspondence. Entirely regrettable. It was a feature of the complete lack of cash with which the SPVs had been left. Lord, as discussed earlier this morning, it was in August 22 the particulars claim was served.
You've got 4 months. You issue in April. You've got until August.
Well, Lord,
So,
yes.
yeah.
And funding came, I think, on the 3rd of August, and
That's what we were told. Yes.
and the claim we know was issued on the 10th.
Served, not issued.
Lord, served. Lord, served.
Issued, I think, on the 14th of April.
My Lord, yes, for limitation reasons, it had to be served back then. And again, as we've heard this morning, following service, Lupton Fawcett raised various issues in correspondence, and that led to the claims preparing APOC 1 and issuing an application to amend. And it was the autumn of 2023 that Lupton Fawcett issued its application to strike out and reverse summary judgment on various grounds, including ex turpi causa, limitation and causation.
There seems quite a long gap between service of the particulars of claim on the 10th of August and a letter in February 23. Was the proceedings put on hold by consent?
There was, first of all, some skirmishes over the parties.
Oh, yes.
Your Lordship may have noticed that Lupton Fawcett is the second defendant. There were 2 groups, the Lupton Fawcett defendants, I think there were 6 from recollection, and 2 or 3 Metis defendants. It wasn't clear who was the correct
So you
defendant.
sued everybody who might be, and eventually it comes down to it's just the second defendant.
Well, Lord, yes.
Okay.
And correspondence was entered into, and your Lordship is right, it did take some time. And just to reiterate what Mr. Doherty said, in terms of these APOCs, I'll do it very briefly. APOCs 1 and 2 were responses to points raised in correspondence, as Mr. Doherty has explained. APOC 3 was merely a revision to the figures in the schedules for limitation reasons.
You took out those which were more than 6 years before issue.
Lord, yes, an attempt was to do so. In fact, it was I think it wasn't quite correct, but in principle, an attempt was made to take out those which were older than 6 years.
Yep.
APOC 4 arose because of the Green documents. We'd seen the reference to Mr. Green, but we hadn't got the documents. We'd asked for them. They didn't come, and then several days before the hearing, they were produced, adjournment by consent, and there were amendments largely dealing with the Green documents. And APOC 5 was because in the intervening period there'd been judgment by some of the company liquidation against Mr. Woodhouse personally. There was a misappropriation claim for some £2.7 million, and so those amendments largely dealt with adding in some features from there, and also in the Metis side of things, some amendments which weren't allowed in relation to various solicitors' disciplinary tribunal proceedings. But in terms of the substance, it was only really in APOCs 1 and 2 with any real change. As your lordships have heard, the matter was heard before Mr. Justice Sheldon over 3 days in February. And there were actually 3 matters before the court. It was the claimant's application to amend against Lupton Fawcett, the claimant's separate application to amend as against Metis, and Lupton Fawcett's application to strike out and or reverse summary judgment. And dealing with the strikeout, Lupton Fawcett's attempt to strike out on the basis of ex turpi causa, that was rejected. The causation attempt to knock out the strikeout was rejected.
Well, there's
Is
two
that factual causation.
factual causation.
Factual causation.
I mean, the suggestion was, and no doubt will still be if the case goes forward, that given that Mr. Woodhouse was determined to promote these schemes, even when he was told in black and white terms this is a CIS, he nevertheless continued with them. And Mr. Justice Sheldon said that's a matter for trial. There's no cross appeal on either of those.
Well, correct.
Yep.
There was also a limitation argument, and that was rejected. But the judge did, of course, accept Lupton Fawcett's argument on the no loss and the scope of duty points, and struck out as against Lupton Fawcett. As for the 2 applications for permission to amend, as against Metis, they were refused.
Yeah.
As against Lupton Fawcett, they were rendered unnecessary, but the judge said that but for the strikeout, he would have allowed the proposed amendments, save for 2 relatively minor matters which have since been removed. My lord, to complete the picture, permission to appeal was sought. There was the order of Lord Justice Bean directing an oral hearing, and we then had the hearing before Lord Justice.
Presumably, you asked Mr. Justice Sheldon and he refused permission.
My lord,
Or did you not ask him?
my lord, no.
You didn't ask him. Okay, that's fine. You don't need to.
They did ask, but he was functus because of the timing of the...
Oh, because you didn't ask at the hearing.
My lord, yes, it was a consequential hearing, so I'm afraid we fell into that trap.
You need to adjourn the hearing so that you need to formally make an application for permission, they bene esse and adjourn it to the consequentials. But anyway, it doesn't matter. You applied, Lord Justice Bean adjourned it to an oral hearing. That was heard by Lord Justice Dingemans and he granted permission.
My lord, yes, and it was following, of course, that hearing that APOC 6
Yes,
the attempt to was in.
We've heard about that.
And to complete the picture, because I note that the time, 2 things. I've mentioned briefly, as for Mr. Woodhouse, shortly before the hearing before Mr. Justice Sheldon, the trial took place. I mentioned that that resulted in Mr. Woodhouse being held liable for some £2.7 million misappropriations. And on the other side of matters, of the split between Mr. Woodhouse and Mr. Forster, Lupton Fawcett were quite separately sued by the FCA for their involvement in the promotion of the Qualia scheme. So on the other side, those schemes are materially identical. And my lord, that case settled earlier this year in January 2025 on confidential terms, and Lupton Fawcett have issued a public apology expressing, I think the words are, their profound regret that they kind of became involved in the Qualia group. That's on the
Not
Qualia
surprised they regret it, yes. Is that a convenient moment?
My lord, yes, it is indeed a convenient moment, and after lunch I hope to address the court on the 3 rounds of appeal.
Yes. We'll see you at 2 o'clock. Thank you very much.
Court rise able.